Boom. Hey everybody, so this video is on the Supreme Court case United States v. Stevens. This fits in with the other First Amendment cases on free speech. New York v. Ferber, Ashcroft v. the Free Speech Coalition, and this one, United States versus Stevens. A couple of things we're looking at in each of these cases that you see the common thread through is what type of speech can the government limit? Why can the government limit that type of speech? And how does the Supreme Court approach different types of free speech cases? Cool? Cool. Okay, so basic background to the United States versus Stevens. In 1999, Bill Clinton signed into law a bill that banned the creation, distribution, advertisement, and possession of animal cruelty videos. So something that's important about this law is, again, it addresses the content of the videos, not the production itself or the actions itself, but what is in the videos. What are maybe the ideas expressed or the substance of the video? What is the speech involved, not the specific actions themselves. Okay, so the law states that there are 5 years in prison for anyone that knowingly creates, sells, or possesses a depiction of animal cruelty if done for commercial gain. And animal cruelty in this case is defined as a video in which a living animal is intentionally maimed, mutilated, tortured, wounded, or killed, and if the content of the video violates federal or state law where the creation, sale, or possession of the video takes place. The law carves out some exemptions for videos that may be videos of animal cruelty but would not be illegal under this law. The exemptions of videos extend to videos or images, depictions that have serious religious, political, scientific, educational, journalistic, historical, and artistic value. So if a video has any of those, can be claimed to have any of those merits or aspects to them, if it's an educational video, then even if it shows animals being harmed, maimed, whatever, it would be okay. If it does not have any of those signifiers or something, then it would be unconstitutional. Or sorry, the video would be illegal. Now, a couple of things the court points out right away. One, the video is illegal if the action in the video violates either a federal law or a state law in the state that the video is being possessed. Okay, the court points out a little later on that D.C., there's a ban on hunting. It's illegal to hunt in D.C. Stretch your imagination a little bit and think about what D.C. is, the various different things of D.C. For example, is it a 100% urban environment? And if you try and hunt squirrels, are people going to be in your way? Might be a reason why hunting is banned in D.C. Also, are there people that work in DC, or maybe even somebody that might live in DC, like maybe live in a big white house, that we might not want somebody carrying around a big gun and saying, hey, I'm out here shooting squirrels, around this area. Good reason maybe for hunting to be banned in DC. Too much chance for accidents or assassinations. Anyway, there are videos out there that purely entertainment, no serious journalistic value or anything like that, where people are hunting and they shoot deer. The court points out that hunting is legal everywhere else in the country except in DC. If you were to buy a hunting video, and then bring it into DC, all of a sudden you're in possession of an animal cruelty video and subject up to 5 years in prison. The court's a little concerned about that. Now, Congress, though, isn't necessarily thinking about those examples when making this law. And as a matter of fact, Bill Clinton, when he signs the law, refers to a very specific type of video or images that this law is meant to cover and ban. This is kind of graphic, so prepare maybe yourself for a description of a video. It's assuming you've already read this description, but okay. The legislative background, if you're following along, page 2 of the opinion. Right. Let's see. There. The legislative background. The legislative background of Section 48 focuses primarily on the interstate market for crush videos. According to the House Committee report on the bill, such videos feature the intentional torture and killing of helpless animals, including cats, dogs, monkeys, mice, and hamsters. Crush videos often depict women slowly crushing animals to death with their bare feet or while wearing high-heeled shoes, sometimes while talking to the animal in a kind of dominatrix patter over the cries and squeals of the animals, obviously in great pain. Apparently, these depictions appeal to persons with a very specific sexual fetish who find them sexually arousing or otherwise exciting. So, that's sufficiently terrible. That's what the law was written to cover specifically. That's in the legislative record. That's what Bill Clinton referenced, kind of, when he signed it into law. However, the case we're looking at here involves Robert J. Stevens, who runs a business selling dog fighting videos. Since in these videos there's an animal being maimed, intentionally maimed, tortured, killed, mutilated, a criminal case was brought against this, and also dog fighting is illegal everywhere. Criminal complaint was brought against Robert Stevens, and he's facing 34 months in jail, or 37 months in jail, something like that in here. He's appealing his arrest and his conviction on free speech grounds, that the law is overbroad and violates freedom of speech. His videos are I think I said already, dog fighting videos. He runs a business called Dogs of Velvet and Steel, and has an associated website through which he sells videos of pit bulls engaging in dog fights and attacking other animals. Among these videos were Japan pit fights and Pickawena, a pit bull documentary. Don't think that's probably a very good documentary. And these videos have footage of dog fights that happened in Japan, where dog fights are apparently legal. They include also videos of pit bulls hunting wild boars and gruesome scenes of pit bulls attacking domesticated farm pigs. Alright, so that's what we're looking at. A couple of things that we'll see in this court case we'll talk about sort of broadly, generally. One, we'll see what test the court applies to First Amendment court cases. So if the government wants to pass a law or enforce a law that bans or somehow restricts certain types of speech or expression, the court has a certain standard that the government has to meet, burden of proof that the government has to meet before it will declare that the law is constitutional, and the government has the right to restrict that type of speech. Just here. So we got that strict scrutiny standard is what we'll see. We also have Miller versus California that comes up over and over again that looks at obscenity standards, and we also will see a couple of times Ferber v. New York and Ashcroft v. Free Speech Coalition. Okay, so the government makes several arguments as to why they think the court should rule in their favor. The court should rule that the law banning videos and depictions of animal cruelty is constitutional, that the law is constitutional, and Robert Stevens, in this court case, should be able to be punished under that law. One thing the government argues is that animal cruelty, videos depicting animal cruelty, should not be a category of protected speech. So there are a couple of different categories of speech where the court says you have to prove to us that you are allowed to say this, not the government has to prove to us that they have the right to restrict you. Some categories of speech, on the face of it, are not protected under the First Amendment. Obscenity, things that fall under the obscenity standard. Defamation of character. Certain libel. It's hard to do that, though. And one that might be readily obvious, child pornography. On the face of it, it's like you're prosecuted for having child pornography. You try and plead free speech. The court will say, yeah, no. Like, we're not hearing it. It doesn't matter. You would have to provide a insanely compelling argument and evidence that somehow your child pornography is free speech protected by the First Amendment. It's just like, that's just not something that is. So we have these exceptions to the First Amendment. Government wants animal cruelty videos to be an exception under this First Amendment. The government points to the fact that the United States, going back to colonial history, has a long tradition of banning cruelty to animals. Dog fights have been illegal, but going way back into the day, just cruelty to animals has been illegal. It's not something you're allowed to do. The court says, well, yeah, so the United States does have this long tradition. And part of what we do, the way we approach cases on the court, when we're sort of reviewing law, is there a tradition of us, the government, performing this act or doing this thing in the past? If there's not that tradition of that, then the law or whatever the government has to do is sort of set up to a slightly higher standard if you want to put there to be a new thing that the government gets involved in. So while we do have this tradition of banning animal cruelty, there is no tradition of banning videos or any depiction of animal cruelty videos. Okay? So the court says, sorry, you don't get to claim that we have a long history of banning these sort of images, videos, whatever. Also, the court says, we are not willing to carve out an exception to the First Amendment for videos depicting animal cruelty. The category is too broad. We need to very carefully look at and decide what type of speech we exempt from the First Amendment automatically, and videos of animal cruelty is not one they're willing to do. It's just too broad, and there's no history of it, being done or offending normal sensibilities, things like that. So the next thing the government argues, or one of the other things the government argues, is that even if you don't carve out this, broad, specific animal cruelty exemption to the First Amendment, the fact of the matter is, any good that might come from an expression of free speech, being able to, disseminate the content of an animal cruelty video, is outweighed by the government's interest in protecting animals, in prosecuting instances of animal cruelty, is outweighed by the need for the government to do its job and enforce the law. One of the things that the government points out is that it's very hard to prosecute crush videos because the identity of the person or persons involved in the video is not known. It's always anonymous, I think is what they said. Often anonymous. So they can't enforce the law by watching the videos, identifying the person, and arresting them. So they've got to do the next best thing, which is to get rid of the videos. They're going to ban the possession and distribution of the videos. Okay? The government says, look, we did this in Ferber. The child pornography, molesting a child, abusing a child, raping a child is illegal. And we then banned the production, the possession, the distribution of videos that have filmed that illegal activity or show pictures of that illegal activity. We did that in part to make sure that there was not an economic incentive for child abuse, sexual child abuse, and raping a child. Because if there is not an economic market for it, because there is no, because the government's banned it, then it's less likely to happen. Same thing they say with the animal cruelty videos. If we can ban this type of video or this type of speech, the distribution and possession of it, then we can effectively eliminate the action also. The court responds to the government's argument saying that the First Amendment is not up for utilitarian discussion. What this means is, while the government says, listen, we're doing this cost-benefit analysis, and we're deciding that the benefit of having that speech is outweighed by the cost of having that speech, the court says that that's not the way we do the First Amendment. The First Amendment is there to protect speech, to protect nearly all speech, and that you can't decide to ban any type of speech based upon some type of cost-benefit analysis. The purpose of the Constitution is to pull certain types of rights that people have outside of the legislative realm, outside of the ability for the state to and the people to pass laws regulating it or banning it. The court also says that this law is overly broad. They are concerned about the fact that the law includes banning videos and images and depictions of animal cruelty that include wounded or killed animals. They cite the hunting example. And the other thing that they object to is the word serious. The law says that if the video, the speech, whatever, has serious journalistic, social, artistic value, whatever, then that's an exception under the law and that speech is protected. The court says, well, who kind of gets to define serious? And also, the First Amendment isn't there to just make sure that all of our discussion in the world is serious. Things that have entertainment value are not maybe necessarily always serious, but we don't get to basically people have a right to entertainment that is not serious. And in addition to that, the court's not willing to carve out this exception to the First Amendment, similar to obscenity or child pornography or defamation of character, things like that. So, sorry, you don't meet we can't do a cost-benefit analysis of this law and keeping it constitutional. We're not going to say that speech has to be serious for it to be protected. And it talks about, looping back around here, to the other part of it, the law, it being overbroad. The law, the legislative history of the law was to ban these crush videos. Here, however, is the law being applied to dogfighting videos. The court says that we cannot, the law is not narrowly tailored to target the speech that the government is specifically trying to restrict or ban. And we have to, in this case, if we want to keep the law constitutional, depend upon the discretion of whoever the prosecutor is in a certain area that would bring these types of cases. It is unacceptable under the First Amendment to depend upon the discretion of a prosecutor as to how they interpret the law, as to whether or not it violates, or whether or not the law violates the First Amendment. When there's a law that violates the First Amendment, you could say, well, let's sort of keep it on the books. There could be a law that part of it is constitutional. Let's say it has to do with speech. Some of the speech that the law touches might be, okay to ban. The court specifically says in here that we're looking at this law as a whole as it relates to dogfighting videos. It could be possible that maybe a law banning crush videos, the videos that the law was intended to target, the torturing of animals for some sort of sexual gratification or whatever. a law banning that might be constitutional. It might not run afoul of the First Amendment. But that's not what they're looking at here. They're looking at a law which says it bans videos that include tortured, wounded, killed, maiming, etc. Animals. The court is, again, not moved by the government's argument that in this specific case of animal cruelty videos, well, I guess more in general, banning a type of speech in order to try and prevent some illegal outcome or some illegal thing from happening cannot generally be applied. They outlawed videos of child pornography to help prevent child abuse from happening. But they also really did that because they carved out an exception to the First Amendment, saying child abuse or child pornography just doesn't get to be speech in this country. They're not saying that they're going to. They are not going to carve out that exception for animal cruelty. The next thing, or the final thing I want to talk about with free speech arguments especially, is the court looks at government regulation or banning or restrictions on free speech under what is called a strict scrutiny standard. Okay? The government has a very high burden of proof, a big giant wall that they've got to jump over if they are going to be able to ban or regulate or restrict free speech or any type of speech. Okay? It's called strict scrutiny. Here is the parts of it, or the test that the government must clear in order for a law to be constitutional. Okay? The first thing the court says is the law has to be related to some compelling government interest, that the government has to have some good, legitimate reason to be involved in this area, and that the category of thing the government is looking to regulate, restrict, or ban is a very, very high priority for the government. So, looking at the child pornography example, protecting children is a huge priority for the government. Very compelling government interest to make sure children are safe. So, it satisfied that part of the strict scrutiny standard. In cruelty videos, especially a law as broad as this, doesn't quite meet that standard, the court says. The next is that the law has to be related to achieving the government's compelling interest. So, the government has a compelling interest in banning child pornography to protect children. Now, the law has to actually somehow be related to that issue. You can't pass a law saying let's look at animal cruelty. The government couldn't say we're going to pass a law banning animal cruelty by banning the sale of TVs. Not related to the compelling government interest. The final standard is that the law has to be written, has to be tailored so as to narrowly meet the government's compelling interest. It has to narrowly relate to achieving that government goal. And it's got to be the least restrictive means of achieving that government goal, that government compelling interest. So even if the government's looking to ban something that it's perfectly within its right to ban, if it makes that law too broad, then the law gets declared unconstitutional and you've got to go back to the drawing board. If the law is very narrowly tailored to achieve that government goal, however, the court, when looking at it and hearing the arguments from the government and the defendant, decides that the government has not written a law so that it achieves the goal with the least amount of restriction needed on free speech to achieve the goal, then the court will throw out the law and say, hey, go back to the drawing board and rewrite this law so that it is the least restrictive means of achieving your interest. So the court may be faced with a law that is very narrowly tailored, but they're presented with an argument that there is a less restrictive way to achieve that goal, a way that lessly restricts free speech. And the court will say, go write that law. Don't bring us these laws that are overly restrictive. So when a court is looking at a law passed by Congress and looking at it under the strict scrutiny standard, the government has the burden of proof, and it's a very high burden of proof that the law is constitutional. You've got to meet those standards. It's got to represent a compelling interest. It's got to be narrowly tailored and rationally related to the government interest, and it's got to achieve the government interest in the least restrictive means possible. So there's that. Be on the lookout for the other videos if you haven't seen them, and reading the cases. Thanks. Bye.